Okay, good afternoon, everyone. I think the audio should now be on for courtroom 8D, as in Delta. We've got a plea and arraignment calendar this afternoon with no one in custody, as best I know. In the courtroom, we have only lawyers, so hopefully clients are nearby. Our first position is State versus Nikisha Easley Manson. Ms. Easley Manson.
Judge, I believe this would be a conflict. Let me double check.
Uh-oh.
I did a little bit of research. I think we had the co-defendant, but I'll double check that.
I will look with you. 877. Of course, there will be no one from the conflict defender's office here. There's only one defendant in the indictment. Oh, there was a co-defendant in the CP land, and Alfreda Williams. And there was a decline to prosecute.
Correct. And I was going to say that we had
Mr. Cho had Ms. Williams, but that is enough that you all need to not be, even though it wasn't prosecuted.
Right. So I'm happy to look into it. I just know that we don't have a file for this person to contact them to let them know about court either way.
Got it. Let's look here. We have an address for Ms. Easley Manson and an email address, a lawyer for her. But it is a 20 CP case.
Judge, if we could have a reset, I'm happy to try to find this person.
The bench warrant was issued, I think it would be a lot easier to find her.
Why is that?
Well, because she would be brought in.
She might be brought in 2 years when she happens to run a stop sign or something. What I'll do, well, Ms. Wood, I don't mean to put you in a bind. If you know that for, I don't want to say policy reasons, I know conflicts are legal and professional responsibility reasons. I just don't know where that line is being drawn by your management these days because of the staffing woes, C2 and beyond. Not that you have extra lawyers in your office, but you're always here. Ms. Feely is always here. Not so with C2 or C3. If you think there is a possibility because the co-defendants, it would have been Mr. Cho who maybe would have met that other person only once, if that, and then it was not prosecuted by the state, that you might be able to keep Ms. Easley Manson's case, then I'm fine doing what we did with, I think it was Omari Ward was the name, where I give your team until the end of the week, maybe we'd say till Monday, since it's already Wednesday, to try to connect with Ms. Easley Manson, because there is a whole bunch of contact info in here, an email address, et cetera. And as I look at the mailing address, it's one of the more potential transient ones, just because it's, in fact, it just has a building number. It doesn't have a specific address. So I don't know if she may still live at building 15 at this address, but it's E7 in building 15. So I'm willing to give you a chance to email her. And let me look. There's even a phone number. And I suspect you have tried neither because it's not your client. Correct. So you tell me how you'd like to proceed.
Yes, Judge, I'm happy to contact Ms. Easley Manson.
Okay.
And see if I can let her know about this.
Why don't we do that? And what I'll do is ask, is this your case, Ms. Willingham? Because of the cruelty to children, or the ag assault is also in your space?
The ag assault appears to be in my space.
Okay. Either way, it's your case. So I'll write down Willingham. And what I'll say is, if we have not received contact from either Ms. Wood or Ms. Easley Manson or some lawyer representing Ms. Easley Manson by Monday, then I'll have Ms. Nelson work with you about doing a bench warrant, and then we'll just move this case to judicial hold because we can't move it forward if Ms. Wood's team is not able to track her down. Monday, which is the 10th, bench warrant. Okay. Let's move along. What's an NB case?
No build.
As in a grand jury said no bill?
Correct, Judge.
Huh, I've never seen that before. It shows you how often grand jury does that. Is that these charges like the state tried twice?
Correct.
Okay. Well, we still need Mr. Fagan. Is this your case, Ms. Wood?
It will be, Judge, and I've been trying to get in contact with him and have not, but I would ask for no bench warrant since he may have been under the impression that the case was over with after the first no bill.
Can you look it up in Odyssey and NB? You can. Look at that.
Oh
my gosh. Criminal no bill. Let me see what this document looks like. No, they just wrote no. Okay, that's what the grand jury should do, I guess. But what you're saying is that the new indictment, so the lead charge in the no bill was that Mr. Fagan allegedly assaulted Ms. Allen by choking her. And I would see very similar language in the 23 SC.
Yes, Judge.
And this all dates back to September of 2020.
Yes, Judge.
Okay. Get over here. So there is a mailing address and a phone number, no email address. I guess you'll try to track him down. I'll just do the same thing till Monday. And if we haven't heard from you or Mr. Fagan, then we'll do a bench warrant, Ms. Willingham. Okay. Emily Adams.
Judge, this is another one. I believe it's another 2020 incident. We did not have a file on Miss Adams. She had a private attorney at first appearance. And unfortunately, it only has the private attorney's last name. So I haven't. So it's an interesting last name, though. So I can look in the state bar, see if I can find.
Let me see. So you have an appearance somewhere? There's a commitment.
It's, if you look at it's not an actual entry, but if you look at the first appearance court action from where the magistrate fills out appearance, there's a name.
Oh, YOXALL?
Yes.
Okay.
Not a name I recognize
No.
from our office.
There are two. There's a Jennifer Yoxall who does Yoxall family law, and that may fit if this is a Ms. Willingham case. And then there's a Peter Yoxall who is an investment manager. So I'm guessing it's Ms. Yoxall if she's even still on the case. But let me look here.
And Your Honor, while you're doing that, the case is currently with my unit, but I've talked to Ms. Willingham this afternoon, and I will be submitting a transfer order, as it does appear that there should be a DV case.
You all have to do internal transfers. You say transfer order. I'm not signing it, but there's someone in your office who signs it?
Yes.
Okay. I'll note that Ms. Adams's address is a post office box in Gulfport, Mississippi. So I think what will likely happen here is that we will just do a bench warrant. I'm not going to ask you to do any outreach because your office isn't even associated with the case. You know, there was at least a hook with Ms. Easley Manson because of the co-defendant. Ms. Willingham or Mr. Jordan, if you'll work on, Ms. Nelson must have just looked for what are some potential bench warrant cases, put them on this calendar. We'll do that for Ms. Adams. That said, if for some reason Ms. Adams gets wind of this and reaches out to your office, Ms. Wood, and she's in Gulfport, Mississippi, we can certainly say, if you just come on in or Zoom in, we can probably take care of the bench warrant.
Thank you, Judge.
All right. Let's move on to Carl Plea.
Judge, he is my client. I have had good contact with him. He actually lives in North Carolina, and it was going to be a hardship for him to Zoom in during work. So I did file a waiver on his behalf.
Okay. But you've got good contact. Let's see what we've got. Let's see. There's some common themes. Willingham, not in Georgia or not able to be found. Yep, I've got your waiver, and it looks like there was already a discovery certificate. Ms. Willingham is all over this. So that's good. We've got a change of address, which says Mr. Poley's trying to keep us apprised, an address in Raleigh. Okay, so we'll just get a scheduling order out.
Thank you, Judge.
Ms. Willingham, anything I need to know about it from the state side?
No, Your Honor.
Okay. Jerry Cozart.
Judge, he would be mine if he were to show up. I left a message with a family member who was going to send a Facebook message to his girlfriend. So I have not heard back.
Okay, these are pretty serious charges.
Also, there's some open CPs if you'd like those numbers as well, Judge.
I will in a minute. I want to see the history of this. So this is just a direct indictment. No wonder he's not here. Let's see. Something from 2018. Okay. One of the alleged victims is a relative. I guess she was a passenger in his car.
Yes, Your Honor, I believe that's at least from my reading of facts, that's the allegation, is that he injured multiple children that were in his vehicle and also his passenger.
Okay, I guess we can talk about the statute of limitations sometime later. I'm just noting that that may be an issue for the state for a number of these charges. But we need Mr. Cozart first. Let's see if he is even connected to, well, there was an apartment in Atlanta at some point. So that at least it's not Gulfport or Raleigh. I'm reluctant to do a bench warrant for something that is coming up on 5 years old. But I don't want to just leave this open either. So what I'm going to do is ask you, Mr. Jordan, to have your investigators run information to see if there is a last known address for Mr. Cozart, if he has bumped into law enforcement anywhere or whatnot, to see if we can get an updated address, because something was mailed to that address. He had a booking. He got booked in March of last year for the same kind of crime, or maybe for this same stuff. I don't know why it would be, because there is a booking number for what I think is this case, a 2018 booking number. And he was in for all of August and he got out. But then he was booked in March of about a year ago and spent 15 days in. Let's see if there's any There he is. Hey.
Your Honor, I do see one of his CPs is from an incident from February 26th of last year.
That may be what this is. So you need to look around. It has his religion in here. I'm just looking for an address.
Is this Kohler?
Yes, ma'am.
Are you looking for it from in probation too?
Okay.
He has a toll warrant, but he's on active probation.
Then I don't mind doing a bench warrant if he's on probation and all that.
Toll warrant out of jail.
Okay, then if you'll take care of bench warrant stuff, Mr. Jordan. It sounds like he's been bumping into law enforcement. There's this March situation, and there may be a good address rattling around in the system. Okay.
Is it Walters Road?
Waters Road. Yeah, that's what I've got, an apartment there. And maybe that's a good address. He may well have gotten something. I'm not gonna come to court. I don't know, apartment F8. But folks could look at the booking. We have a driver's license number. So I think there are ways to triangulate on him. But I will sign a bench warrant, having heard from Ms. Tucson. And finally, I know we've got the lawyer on the call. We've got Ms. Engaben. Is that your? Hey, Mr. Bixon, how are you?
Good to see you.
Same. Let me.
And Miss Engaben's on the call, Judge.
Yep, I see her. We're going to add her to the spotlight. There she is. Who's handling this for the state? That means Mr. Jordan.
I can handle this, Your Honor. I believe it would belong to another unit. I looked up the case and I'm familiar. I understand that it was in PTI.
Right. And we're really just checking to see if Ms. Engaben has done what she needed to do. Let me call the case up as well.
Judge, she has done everything just while the court looks it up, and she submitted payment for the restitution yesterday, so everything should be complete.
So I had to sign an order a few days ago. I guess to diverse, I guess that meant disperse money. So Ms. Catchings was able to get out of the registry, or should be able to get out of the registry, a certain amount of money. Let me see what else we've got. Here's the judicial hold.
Judge, if you don't mind me asking, when did you receive the order for the restitution? I'm genuinely curious about this.
It would have been close in time to when I signed it. So I would say mid-March. It may have come from, is Ms. Toole who runs the diversion? So it may have come from Ms. Toole. Were you not copied on any of that, Mr. Bixon?
Well, we had a lot of issues with diversion, and I understand that the Fulton DA's office has restructured their diversion, or at least from the looks of it, they have, but we were trying to get them to send that order in since like November, Judge. I mean, following up with them constantly, and I'm just like, this is the first time I've ever had that kind of issue with diversion, and I don't know if it's something because they restructured it or what, but it was a mess.
Okay. Well, my advice to you next time is, if it's a case with me, reach out to Ms. Nelson, and then we'll just set it down, and diversion will have to show up and answer. So I don't mean for you or your client to have to go around in circles. I do know, having met with Ms. Toole recently on a completely unrelated topic, that they're swamped because they are, in a very commendable way, sending more people through diversion. And so you and your client may have been caught up in that tsunami because they're trying to process all the incoming folks. And that's not an excuse, it's an explanation. But they're going to need to staff it so that we can get the results that are expected of all the stakeholders, whether it's the clients in it, the judge to whom the case was assigned, the lawyer for the client. But again, if another one of your clients goes through that process and you all get stymied administratively, reach out to the judge, because it's real easy to say, we'll put it on an inquiry calendar and poor Mr. Jordan will come in and he'll have to answer the questions. And if not, he'll get a real short fuse to get the answer to the situation. I need to know when we can, looking at the order I signed in March of 2022, not the restitution piece just a couple weeks ago. There was some community service, restitution, which it sounds like has been paid, some coursework, et cetera. How do I learn from the DA's office if Ms. Engelben has done everything she's supposed to do?
Your Honor, I believe when all outlined terms are completed, they usually notify us, like the trial unit, and they'll say that all of this has been completed, and they will dismiss the case.
Okay.
Is my understanding.
That assumes that the push is working. What I'm hearing from Mr. Bixson is we may need to do pull to say, I'm the line attorney in 8D. I need to know if Engelman has done what she's supposed to do. So why don't we do this? I don't want to drag any of the three of you, defendant, defense attorney, or prosecutor, back to court on this one unless absolutely necessary. If you would, by next Wednesday, Mr. Jordan, get an email to Ms. Nelson and me and Mr. Bixson, letting us know if Ms. Engelman gets the green light and when the dismissal will be filed, meaning the NPGJ. And if something is not complete, what is that something? So don't simply write back saying she hasn't done it all. It would be she hasn't done the 3 to 5 page essay. Then I'll set a deadline for that because Mr. Bixson and his client seem to think they've checked all the boxes. I'm not taking their word for it. I'd want to hear both sides on that. So you've got a week to pry that out of diversion and shoot an email to everyone. And it'll either say done and here's the dismissal, or here's what's missing. And if we can go back and forth on email. If that falls apart, then I'll put this on another inquiry calendar and everyone will need to appear virtually at a minimum so we can figure out what the situation is. Mr. Bixson, does that work for you?
No problem, Judge. I thought that diversion had already sent everything over showing that she completed it, but I guess they hadn't.
That would be correct. I've seen no report. So, Ms. Engelman, do you have any questions about anything we talked about?
No, I do not. I do want to say I did send everything via PDF file to Deputy Henry, which is where I was instructed to send everything. So I don't know if there's another contact that I could just forward that email to, because it does have all of the requirements that I had to meet on that email. So I don't
actually, Judge, if I just could inquire from Ms. Engelman, do you have everything in PDF format right now?
Yes.
Judge, could you just send it or to your office or to the court or something like that to show that she's finished everything?
So she could, but the way this is structured, it's not my call to make. Of course, I can't dismiss a case anyway, but I like this notion. And so if Ms. Engelman would send it to Mr. Jordan as the prosecutor in this courtroom, that will make me even more comfortable a week from now if Mr. Jordan says, I don't know what's going on, to say, that's not an okay answer. Because it may be that Mr. Jordan gets to the right person. And it could well be that ADA Henry was the perfect person. And I'm right now, my blood pressure is very low about this, again, because my sense is that they're overwhelmed with too many, maybe is the right way to describe it, folks in pretrial diversion. And that's a good thing.
I'm all about it, Judge.
Right. It's good that people are being directed in that way, but they're going to need to work on the customer service piece so that we can close out those that ought to be closed out. So if Ms. Engelman, if you just send to your lawyer, I know this is going to be multiple steps, send to Mr. Bixson because you've got his contact information, all that stuff. He'll send it to Mr. Jordan. Mr. Jordan will have it. That'll make it easier for him. If someone in diversion says, I don't know who you're talking about, or we don't have this or that, he can say, here it is. Here's the check. Here's the essay. Here's the vision board, whatever it needs to be. And then again, I will wait patiently for up to a week to hear from Mr. Jordan or a colleague as to the status of Ms. Engelman's situation in that pretrial diversion.
That'd be great, Judge. And Mr. Jordan, if I could just get your email, and I'll send that on over to you today.
Sure, absolutely. It's JULIAN period Jordan JORDAN. Gotcha. Got it. All right.
Perfect. All right, Judge, we'll go ahead and get that email out today. Thank you so much.
Sure. You bet. So we'll get that update no later than April 12th, which is next Wednesday. As to status, and it may well be if the email says we're dismissing, then I'll just look for that dismissal. Only if there is some static between the two sides will I need to get folks back on for another inquiry. Okay?
Wonderful. Thank you, Judge.
All right. Thanks, everyone. You are free to go.
Bye-bye.
Thank you.
Bye. Ms. Jackson, that's it. Short and sweet. No pleas, unfortunately. In fact, very few defendants, unfortunately. But we will see you next time.
Thank you, Judge.
Judge,
Thank
no,
you.
we do have police. We have two
Oh,
police this
Right.
afternoon.
I forgot. It's so good. Miss Nelson's here. She's like, Judge, you're such a dope. We do. Don't go anywhere, Miss Jackson. Not so fast. Let me look at the calendar. So you are free to go somewhere till 2. At 2 o'clock, we're taking a plea, and at 2:30, we're taking a plea. But if folks want to be at ease for a half hour, that's fine with me. And Ms. Willingham's already packed up. They're not her pleas. So I will see you, Mr. Jordan, at 2. Is that your case, Ms. Wood?
It is not, Judge.
Oh, who's got Mr. Kearse?
It is a
Private
private
attorney?
attorney.
Okay. It's all right. She'll either dial in or be here at 2, and then we'll pivot right after that to Fegerland, which is Mr. Rousey on one side and Shapiro, but I think we'll get McCauley at 2:30. So the Zoom will stay up. And Ms. Jackson, if we could have you pop back in at 2, that would be great, and we'll take care of 2 please. All right?
Will do, Judge.
Thanks, everyone. And Ms. Tucson, we'll need you for those as well. You're welcome to stay right there or shuttle back. Excellent. Okay. If you're more comfortable in the jury room because there's a table, or you can sit at council table. You're not banished to the jury box. All right. Great. I'll come back in half an hour. Almost let everyone go. It's bad.
Okay, I'm just gonna file this last waiver from this morning.
All right, we should be live with our folks who are connecting remotely. And I think the first plea we're taking is Mr. Pierce's. Let me find it on the calendar. Is Mr. Ross going to be a guy who works his cases out? Do you know?
I believe so, Your Honor.
TBD.
Yes, definitely.
Okay.
I believe one way or another, they will work out.
All right. Ooh, Mr. Brisky pled. Let's like that. Yes. Right. He's the one who wanted to tell us all about how it was his ex's fault. Mr. Fegerland. There's Mr. Pierce. Just one case. All right. And Ms. Watts, you are Mr. Pierce's lawyer?
Yes, sir.
All right. Let me get all of you. There you are. And let's add him.
Onto it just to be logged on.
No, because no, and just in case there's a speaker issue or something, I don't, that's all right. If we need you to interact with folks, you can always go to the podium.
And Your Honor, just as a heads up, I believe the victim in this case wanted to give a victim impact statement.
Sure, is that Ms. Quinn?
I believe it may be, the victim's name is Ms. Sybil McBee. I'm not sure if Quinn is her or not, but I did.
Okay. I will make sure.
Quinn is my middle name, sorry.
Pardon me?
Quinn is my middle name.
Okay. But you're the person to whom Mr. Jordan just referred.
Correct.
Great. At the appropriate time, I'll be happy to hear from you.
Thank you.
Thank you for being here. Okay. I think we're ready. Ms. Rivers, are you ready?
Yes, I'm ready.
Great. All right. This is position 30 on our trial calendar that will be called next week. The style of the case is State versus Tremont Pierce. It is indictment 22 SC 184582. Mr. Pierce is charged with 2 counts of aggravated assault and 1 count of criminal trespass. It relates to an incident that allegedly occurred on January 30th of last year. Mr. Pierce is online. His lawyer is also appearing virtually, and Mr. Jordan is the prosecutor appearing here in court. Good afternoon, Mr. Pierce. Can you hear me?
Yes, I can hear you, Your Honor.
Great. I need you to share with me your willingness to move forward with this matter virtually. In other words, you're not here in court, you're appearing remotely, which is fine, but I need you to state on the record that you waive your right to be here in public court.
Yes, sir. I waive my right.
Okay. You also have the right to have Ms. Watts right next to you, so you can lean over and ask her a question or confer with her. We can still make that happen by putting you in a breakout room, but structurally, you two are in different places, and I need you to share with me on the record that you waive your right to have Ms. Watts by your side for this plea.
Yes, sir, I do.
Okay, and will you let me know if at any point you want to speak with her privately?
Yes, sir.
Good, we'll make that happen. Ms. Watts, are you ready to go forward?
Yes, Judge, we're ready.
Great. So what's going to happen, Mr. Pierce, in just a moment, is that Mr. Jordan is going to put you under oath. Once you're under oath, you need to answer his questions and mine truthfully and completely. And as I mentioned, if you've got questions or concerns, you need to let me know, wave your hands, do something so we stop, and either I'll answer your question or Ms. Watts, as I said, can get you into a breakout room so you two can discuss. Will you let me know if you've got any questions or concerns?
Yes, sir.
Okay, Mr. Jordan, when you're ready.
Yes, Your Honor. And just for the record, the state will, this is a plea to only count one, aggravated assault with a deadly weapon. State will move to dismiss counts 2 and counts 3 in exchange for a plea to count 1, Your Honor.
Okay, understood.
Thank you. Mr. Pierce, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Tremont Lamarius Pierce.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 30 years old and I have a bachelor's degree from Clarkland University.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the offense of aggravated assault with a deadly weapon?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney, Ms. Jennifer Watts, about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Watts, do you waive formal reading of the indictment?
Yes.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Kearse's name?
Yes.
Mr. Kearse, do you recall being arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to this charge. Ms. Watts, do you know of any outstanding warrants related to this charge?
I do not.
Mr. Kearse, has your attorney advised you the minimum and maximum sentence for the charge that you're pleading to today?
Yes, sir.
And Your Honor, just for the record, the minimum for aggravated assault with a deadly weapon is 1 year and the maximum is 20 years.
This is not charged as aggravated family violence, aggravated assault. So that's the right range. I guess you're going to get into the factual basis and I'll understand what connection Ms. McBee and Mr. Kearse had.
Correct.
But I just wanted to be clear on the record that whatever their connection may be or may have been, this was not charged by the state as a family violence aggravated assault.
Yes, that's correct, Your Honor.
Got it.
Mr. Kearse, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, in regards to count 1, which is the sole count that the state is proceeding on, the state's recommendation is 3 years probation. The special conditions of probation that Mr. Kearse have no contact with the victim, that he undergo a substance abuse evaluation and follow recommended treatment, and also that he attend and complete an approved anger management course and provide proof to probation of completion of that anger management course. Mr. Kearse, was that the recommended negotiation that was communicated to you?
Yes, sir.
Do you understand that the court does not have to accept that recommendation?
Yes, sir, I do.
Do you understand that the court can sentence you to the maximum on this charge?
Yes, sir, I do.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
I don't believe you are, but are you currently on probation or parole?
No, sir.
Do you understand that since you are being placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and finally, your ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
And Mr. Pierce, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
Have you ever pled guilty or nolo contendere or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, sir.
Have you ever been sentenced for any crime, whether that be a felony or a misdemeanor, under the First Offender Act?
No, sir.
Has your lawyer, Ms. Watts, explained the First Offender Act to you?
Yes, sir.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge that you were pleading to in this indictment?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Pierce, how do you plead to the charge of aggravated assault with a deadly weapon and indictment number 22 SC 184582?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since this is a felony, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Your Honor, since it is past the status calendar, Mr. Pierce would not be able to withdraw his plea.
That's correct.
Correct. Okay. And Your Honor, for a factual, and my apologies, Ms. Watts, have you advised to Mr. Pierce his deadlines for filing a direct appeal?
Yes, I have. And I did not understand the last statement. So are we saying that if the court is not inclined to follow the recommendation, he would not be allowed to withdraw the plea?
That's right. Let me just confirm. I mean, that's what I said, but let me make sure. Yes, Mr. Pierce had his status conference or final plea conference on the 17th of March. That was the time if this case was going to resolve short of trial and Mr. Pierce wanted to be able to withdraw his plea if it didn't go the way he wanted, that would have been the time to take the plea. But here we are now in April. So that right, and it's a lowercase r right, it's not a constitutional right, but a privilege that some judges allow certain defendants to have in certain situations, that has expired. So we are now at a point where Mr. Pierce is saying, I know I don't want to go to trial. And is this a negotiated plea?
It is, Your
So
Honor.
there's going to be a joint recommendation, which is influential because the people who know the most about this case are obviously Mr. Pierce and Ms. McBee, and then the two lawyers who've been involved. So I will certainly factor that in. But if I decide, just as an example, Mr. Pierce should have 5 years probation, that is a more severe sentence than what was negotiated, and that'll still be Mr. Pierce's sentence. Do you understand that, Mr. Pierce?
Yes, Your Honor.
Okay, and understanding that, you still want to go forward?
Yes, I do.
Okay. Ms. Watts, anything more you want me to add on that front?
At the time that we had the status conference in this case, the defense did not have all of the discovery. We were not able to download some of the information that had been sent to us by the state. We were hoping that the court would allow us to withdraw the plea if the court is not inclined to follow the negotiated plea, since we received that after the status conference.
So a couple things on that front. One, tell me just generally what it was that you got, I'll say belatedly. It may be that the state sent it before, but it was in a format that you couldn't open. But was it something essential like Ms. McBee's statement to law enforcement, or was it a little less essential like the fingerprint cards for Mr. Pierce when he got booked in?
It was the video.
The video of what?
From the officer. To be honest with you, we still have not been able to download it, and we have not received it. But Mr. Pierce believes that it's in his best interest to move forward. We had asked on the plea sheet that was sent to us that Mr. Pierce be allowed to enter this plea under the offered plea. He understands that moving forward, there was some risk that he would be taking. So he thought it in his best interest to go forward with the plea. And also in reference to the hectic trial calendar that I have coming up next week, we were able to work out to get on the court's calendar for today so that we would be able to resolve that prior to the calendar and avoid any conflicts that I have with the trial calendar that I have coming up on Monday.
Got it. Okay. That all makes sense. And so what I'm going to say is, let's see. I don't know anything about this case. I'm going to need, well, I mean, I know some. I've read the indictment. I've heard what everyone's been saying today. I'm going to need to hear from Mr. Jordan as to the state's factual basis. I will certainly hear from Ms. McBee. She's got a right to be heard. And then Ms. Watts, I'll hear from you. And if Mr. Pierce wants to add anything, I'll hear from him. And if I hear all this and say, you know what, I think Mr. Pierce needs to go to prison for 5 years, he can back out of this and say, I'd rather go to trial and run the risk of being stuck with whatever sentence would flow from trial if he's found guilty, because of course you don't get to say no thank you to the sentence you get after trial. And you might not be given first offender after trial either. So you control more right now than you would if this case goes to trial and there is a guilty verdict on any one of the 3 counts, because of course the state could go forward on all 3 counts. I just don't know enough right now to say I think that 3 years probation is not the right outcome. And it may be that I think it's not the right outcome, but what I think is the appropriate outcome is something that Mr. Pierce and Ms. Watts, you still want to go forward with. So let's assume that if I depart drastically from this recommendation, then you probably will be able to withdraw the plea. But I can't say that for sure yet. Okay.
Yes, sir.
All right, let's press on. Mr. Jordan.
And Your Honor, for a factual basis on this case, if this case had gone to trial, the state believes it would have been able to show beyond February 30th of 2022, an officer from the Atlanta Police Department responded to 450 Piedmont Ave Northeast in result of a dispute. When the officer arrived on scene, he was met by the victim, Ms. McBee. Ms. McBee stated a male by the name of Mr. Curse came to her home extremely intoxicated and upset. When asked of their relationship, Ms. McBee explained that they do not have kids together and sometimes see each other, but not enough to call themselves dating. She continued to explain that Mr. Kurz came into the location drunk, and to calm him down, she decided to cook food for him and have him relax. He then became even more upset when he could not find the keys to his black 2018 Dodge Challenger and decided to accuse Miss McBee of having them. Miss McBee told him multiple times that she did not have the keys, and after a short amount of time, he started to yell at her. At this point, Miss McBee decided it was time for him to go and started to demand that he leave. Mr. Kurz refused, but once he found his car keys, he proceeded to leave. But before leaving, he decided to throw and break a glass of wine, damage a set of blinds, punch and damage the wall in the living room, and kick dog food around the apartment. Miss McBee was afraid at this point and tried to push him away and out of the house. But as she was doing so, Mr. Kurz pulled out a firearm and struck her in the face. Once the gun made contact with her face, it caused a laceration to her lip, causing it to bleed. The officer did ask for the make and model of the gun, but Miss McBee was only able to provide that it was a black in color handgun. She also stated that once the gun was drawn, she ran upstairs in the closet and called a friend for help. Miss McBee states that Mr. Kurz then got inside of his Challenger and revved the engine. As he finally left the location, gunshots were heard around the same time he was leaving. At least to the officer, he was not able to find any shell casings. And EMS did come out to check on Miss McBee's injuries. Miss McBee did provide an Instagram account for Mr. Kurz and his home address. Warrants were then taken out for the offenses of aggravated assault and at that time also criminal trespass. Your Honor, would you like to hear Miss McBee's victim impact statement now?
In just a moment, I got a question about what you shared with me. As I understood you, Ms. McBee reported to the responding officer she was struck in the face with the gun and that caused her lip to bleed, caused this laceration. Is that merely Ms. McBee saying that, or does the officer's report say, I could see that she had a busted lip?
Your Honor, I believe that we have pictures, and this may have been one of the few bits of evidence that I was able to send Ms. Watts outside of the videos that were downloaded. There are pictures of the inside of her lip that shows a laceration.
Okay. All right. That's all I had. So yes, I would. Is this something you're going to read or Ms. McBee is going to share?
I believe Ms. McBee is going to share it, Your Honor.
All right, Ms. McBee, this is your opportunity. Should you like to, you are not required to say anything at all, but you've got a right to share with me how this situation has affected you and what you think ought to happen in this case. I will certainly factor that in as I sort out what I think is a fair outcome.
I mean, pretty much what he just said was very accurate. Now I have limited use of my jaw because where I had jaw surgery in 2007. So with the impact from the gun on my face, it has impacted me a lot physically, being able to eat different things. So it's just the mental, physical, everything has been. Since then, I think about it every single day, and I just want closure. And I think about his kids, and he is a very present father, I do think, but also I want to see his ass in jail, honestly. So I don't have a lot to say. It was very accurate with the count. There are pictures and evidence that can be sent to support this, but I had to think, you have kids, cool, but also my life has been affected so much in the last year.
Sure.
And I need the closure, and if you have to go to jail, send his ass to jail. Like, you deserve it. This is not the first incident that we've had. It's the second incident, and I can't tolerate it. I don't think it's appropriate for anyone to do that to someone. Like, why would you do that? Why? Like, I don't understand why you would do that to someone when you asked to come to my house and sleep on my couch because you were drunk and you couldn't make it to your house. Then I want to feed you and I make sure that I take your keys so that you're not driving off drunk, and you let my dog out the house and you fire off 4 shots also on top of hitting me. Like, I don't know where all of this is. I don't know. Like, why would you do that? Like, to someone that's been so kind to you. I have $5 in my bank account and you asked for something, for me to get you something from the gas station for $3, and I left myself at $2 because you wanted something. And this is what you do to me, CK? Like, this is what you do to me? I've helped your ass so fucking much. And this is what you do to me?
So Ms. McBee, I appreciate you sharing that. If there's more you're going to say, you need to talk to me, not to Mr. Pierce. He's got a different role in this, but I hope that you sharing what you're sharing is part of, as you said, the closure process that you're seeking. How long had you known Mr. Pierce before this situation? I understand you said there were 2, but the one that's charged and is before me is this one. How long had you known him?
I met him in I moved here in 2012. So I think maybe 2013 is when we first met.
Okay, so you've known each other for a while. You've referred to kids. My understanding is that you and Mr. Pierce do not have kids together, but you're aware that he is a father. And so you are, and I think this is very compassionate of you because you aren't in the position to necessarily have to feel any compassion at all in his direction. And it's for his kids and not for him. I get that. But it's your understanding that Mr. Pierce is a father. And so one of the things you're weighing is wanting those kids to have their father present in their lives.
Correct. But if he didn't, if I would prefer prison, but if he didn't have kids, I would.
You would what?
I said I would prefer him to go to jail, but if with the kids, I think people need their fathers present. So.
Okay. Well, you're being thoughtful about it. I have had victims before say that these kids ought not to be around this person because of how he treated me. But I appreciate you sharing that. Has Mr. Pierce attempted to contact you since he got a bond in this case, a condition of which was to leave you alone in every respect?
A few weeks after, or a week or 2 after it happened, he reached out through a mutual friend that I went to high school with in Cleveland Heights, Ohio. We know each other from when I lived in Ohio, and he texted me and asked me if someone could talk to me, and I have it recorded. I will have to pull it up, but I have it recorded, and I said, "Is this person Tremont?" And he said yes.
Okay. Shouldn't have happened, but beyond that, has there been anything?
No, not since.
Okay. So you've been able to, as best you could, despite the stress and the jaw and it sounds like daily reminders, you've been able to move forward I won't say in peace, because clearly this still is something that weighs on you. But Mr. Pierce has not been indirectly through a shared friend or directly been bothering you in any way.
No, that was the only time I said violence is not acceptable and you don't do this to the person. And I sent the photos so that we could share them with him if he needed to. And that was the last contact that I've had with Tremont.
Okay, that's good to hear. All right. Is there anything else, Ms. McBee, that you want to share?
Mm-hmm.
No? Okay. Well, thank you for being here. You're welcome to stay on this session until we're done. You're also free to leave if you want to go.
Okay. What's the next steps, or what are y'all going to discuss?
Well, you'll find out. All right.
And Your Honor, very briefly, if I may, I had a conversation with Ms. McBee maybe a week or so ago, and it was very similar to the account that she just gave. We spoke about a probated offer only, and one of her main concerns at that time was definitely that she believed that Mr. Pierce may have had a substance abuse issue because the alcohol led to this particular incident. I shared with Ms. McBee that he did not have a lengthy criminal history. In fact, as I would, upon his last look at his GCIC, he only has one conviction for a marijuana possession, 2015 out of Cobb County. So that was part of the state's reasoning in giving this particular offer to Mr. Pierce, given the lack of his criminal history. But the state is very much understanding of the emotional toll that is taken on Ms. McBee.
Sure. Okay. Ms. Jackson, good afternoon.
Good afternoon, Judge.
Can you share with me what you have for criminal history for Mr. Pierce?
Yes. The defendant has 2 cycles. The defendant's last arrest was March the 1st, 2015 in Cobb County for possession of marijuana less than an ounce. He has 1 misdemeanor conviction that was in 2015 out of Cobb County for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you, ma'am. All right, Ms. Watts, share with me what you want to concerning your client and this case.
Judge, I can't hear.
Yeah, I can't hear you, Ms. Watts. It doesn't say you're on mute, but I can't hear you.
Can you hear me now?
Yes, ma'am.
Okay, I'm sorry, Judge. So I'd like the court to know that Mr. Pierce, of course, he's 30 years old and he has no previous criminal history other than what Ms. Jackson has stated to the court, and he has no other violent criminal history at all. Since that time, he has not had any contact. I was not aware of the contact, but I guess other than what has been stated by Ms. Quinn, he has no desire to have any contact with Ms. Quinn. He is gainfully employed and has been so for some time. We'd ask the court to take that in consideration. He is an active father and does help take care of his children. We'd ask the court to take that into consideration, that he provides for his children. We'd also state to the court that if we were to proceed to trial, of course, the account of how things happened that night would be a different account for Mr. Pierce, but he does wish to move forward in the plea. We'd ask the court to allow him to avail himself to the first offender provision. We'd ask the court to accept that. I think that he is eligible. Well, he is eligible for that. We'd ask the court to consider the facts that were submitted to the court, in that Ms. Quinn indicated that there were some shots fired during that night, and upon investigation, there were no shell casings found at the scene. There was nothing to validate the statement that was made by Ms. Quinn. We'd ask the court to take that into consideration and to take into account all the things that we have said to the court. And I believe that Mr. Pierce spent approximately a week in custody before getting bond.
All right, but the system shows 3 days, but either way, it clearly wasn't you're arrested and then you walk out the back door.
Yes, sir.
So I hear you on that. Mr. Pierce, I've got a couple questions for you, and then you also have a right to be heard if there's anything you want to say to me. And I want to emphasize the to me. There may be things that you want to communicate to Ms. McBee, but you'll be talking to me, and I need you to stay focused in that way. My questions are in 2 areas. One, professionally, what is your job?
My title is creative coordinator. I work at Tyler Perry Studios. So I handle everything creatively over here from the studio side aspect.
So they do everything there. You are the creative coordinator for everything. You're for movies and music.
It's a team of 4 of us, and we do the scripts for the show, TV shows, scripted movies, the plays. Yes, everything above the line.
How long have you been at Tyler Perry Studios?
I've been here for going on 4 years full time now.
Okay. The second area is kids. How many kids do you have?
4.
All right. Are they all with one mom or different moms?
Different parents.
Okay. Are they all in the Atlanta area?
No, sir.
Are there any in the Atlanta area?
Yes, I have 3 here and 1 is in California.
Okay. And what's the age range?
The oldest is 7, the youngest is 5 now. He just turned 5 February 13th.
Okay. Yeah, I guess it would have to be more than one mom if the age range of 4 kids
So
is
close. Yes,
5
sir.
to 7.
Yes,
Okay.
sir.
The 3 who are here in Atlanta, how often do you see them?
It's a weekend type basis, but I do pick up my son Tristan for school every day to take him. He's the 5-year-old. I have to pick him up daily for school.
Okay. Where does he go to school?
Wings of a Dove Academies and off of Snapfinger Woods in Decatur. So he lives with his mom there, and I pick him up from there, and then I take him to school.
Okay. Got it. Thank you for filling in those blanks for me. Anything you want to add about this situation or your situation in general?
No, Your Honor.
All right. Well, Mr. Pierce, let me start by talking about first offender. First offender is primarily an opportunity for someone who fits your description. You do not have any felony convictions. You've got this one very minor misdemeanor from 8 years ago in Cobb County. If you are sentenced as a first offender, what that means is you will have a sentence and you will serve that sentence. But if you successfully complete it, you will continue to have no felony convictions, which is helpful professionally. It also means you can continue to vote, et cetera. While you are a first offender, meaning while you are under sentence, it is a felony offense for you to have a firearm. So whatever was going on in January of last year, that obviously can't be repeated in any dimension. You can't put your hands on or a weapon on someone else the way it was alleged in this case, but you can't have a gun around you while you are under sentence as a first offender. So the upside is it's not a conviction. If you are trying to advance yourself professionally and someone says, hey, man, I need to know your criminal background. Are you a felon? The answer would be no, even if you're still under sentence at the time, because it's not a conviction. And as I said, when the sentence is done, you can have it discharged. It doesn't mean that nothing happened to Ms. McBee. It means that your criminal history will remain, we'll call it clean. It'll have that little marijuana misdemeanor on it, and that's it. That's valuable. But that comes with a risk. And the risk is that if Mr. Pierce in a year from now or 6 months from now, or frankly, anytime during your sentence, if you get arrested for something else, especially something like this, where you're out of control and you're putting your hands on someone in a way that you shouldn't, not only will you have those new charges, but you'll come back in front of me and the state could ask me to, and I likely would, not just revoke your probation, but revoke your first offender status. And without a trial, because you've already pled guilty, I would resentence you as a felon. So there goes the criminal history. And this is the big one. Let's say for a moment, I follow this recommendation and sentence you to 3 years. I would be able to undo that. And I'd have that whole range of 1 to 20 years. And so just as a hypothetical, if we're together again in 6 months because you busted another young lady's jaw because you were drunk and lost control, I can almost promise you that you'll go away 5, 6, 7 years. On this case, I don't know what will happen with the new case, but I'll be able to revoke and resentence you. And Ms. Watts is a great attorney, and she'll say, Judge, please don't do that. But it's not going to be her fault. It's going to be your fault. And I say that not because I am forecasting that you would do something like that. You have a lot riding on staying sober and staying peaceful. You've got kids, you've got a job, et cetera. So you've got incentives to be smart about this. But sometimes people who are skilled, like you may be, also are working through some situations, whether it's drugs or alcohol or stress, and you're going to get yourself in another situation and we'll have another Ms. McBee. You just need to understand that if that happens while you're on first offender, it all blows up and you could be resentenced as a felon up to 20 years to serve on this case and not just the new one. Do you feel like you understand, Mr. Pierce, the benefit of first offender and the risk of first offender?
Yes, Your Honor, I do.
Do you have any questions about what I just said?
No, sir.
Do you still wish to be sentenced as a first offender?
Yes, sir, I do.
Okay. Mr. Pierce, I find that there is a factual basis for your plea. In other words, if the state were able to prove all the things that Mr. Jordan said occurred, and as Ms. McBee has confirmed, a jury could find you guilty. I'm not saying they would, because Ms. Watts has helped me understand, and it was a little indirect, and I appreciate that there's another side to the story. And you, of course, would be able to present evidence at a trial as well. But if the jury credited the state's presentation, the jury could find you guilty. So I find there's a factual basis. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we discussed. Is that a true statement?
Yes, sir. Your Honor, it is.
Any questions about anything we've discussed?
No, sir.
All right. And voluntary simply means no one's forced you to enter this plea. It's not a happy moment for anyone involved. Hopefully it is bringing some closure to Ms. McBee, but this isn't a good moment for anyone. But no one's forcing you to do this. Is that a fair statement?
Yes, Your Honor.
Okay, then I will accept your plea. I'm sentencing you to the Probation Options Management Act, which means the part of your sentence that's on probation. If you violate that probation, but you do so in a minor or a technical way, probation and you will sort that out. I don't have to get in the middle of it. But if it's more serious, you violate any of your special conditions, and I'll tell you what those are in a minute, or you get arrested again, which would be a violation of a general condition, that comes back to me and we will work through the consequences, one of which could be that you lose your first offender status. Mr. Pierce, tell me what your work schedule is. It sounds like because you're on the creative side, it's not necessarily, well, it's Monday through Friday, 9 to 5, but in general, what is your work schedule? Is it a Monday through Friday or how does that go?
It's definitely Monday through Friday. Sometimes it carries to the weekend, but I'll say maybe 9 to 6 to 7 p.m.
How is it that you're able to get away to pick up I think it was your son, to get him to school, or that's at the beginning of the day?
That's at the start of the day. So what I take him and then I come in I had to be here like 9:30 to 9:40 now, but they allowed me to do that for the time being.
Okay.
And the mom doesn't have a car for the time, so I had to step in to help out.
So how does he get home from school?
She's Uber. We have to pay for Ubers. She's Ubering him and I pay for him to go back.
Okay. That's an expensive chauffeur. Got it.
Super, super expensive.
Okay. All right. So Mr. Pierce, I'm going to follow in part the recommendation in this case. And I'm going to lay out all the conditions and then you and Ms. Watts can talk. I can put you guys in a breakout room and then you'll let me know if you want to go forward with this. I'm going to impose a sentence on count 1, which is the only count the state's going forward on, of 4 years probation. I will set a behavioral incentive date of April 6th of 2025. And what that means is if over the course of the 2 years, there have been no issues with probation, you've left Ms. McBee alone and you've complied with the other things I'm about to explain, then probation can come to me to say, you're wasting our time supervising Mr. Pierce. This guy is minding his own business, doing well. Could we please focus on the guys who are high maintenance? And if all is going well, then we can shut down your probation a little bit early. But I'd like a little longer tail in case things don't go well. Special condition of your probation number 1 is absolutely no contact of any form with Ms. McBee. You don't write her, call her, post something on your Instagram that anyone who reads it could figure out, hey, that's about Ms. McBee. Similarly, you don't rely on an intermediary, a shared friend or acquaintance to reach out to Ms. McBee, whether it's to say, I'm real sorry, or to say, I can't believe you lied on me this way, I'm going to get you. If Ms. McBee can document that you were attempting to communicate with her, we will all be back together again. And Ms. Watts is going to really need to pull out a Hail Mary to keep you out of jail. So you need to allow Ms. McBee to heal and move in her direction and you go in a different direction. It sounds like you've done that 98% of the time since you got arrested for this. You just need to keep doing that. Is that clear?
Yes, Your Honor.
Okay. You will also need to complete what is called a family violence intervention program. That is a little different from anger management. It is a little longer and it is a little more comprehensive. It's not one class, but it's a series of classes that you would take over a series of weeks. So you don't have to sit down on day one and knock it all out. In fact, you can't. But probation can help you connect with a family violence intervention program. You'll need to complete that. You will also need to submit to a drug and alcohol abuse evaluation. And that's an opportunity for you to meet with a professional who can help you assess whether there's something going on in your life that's causing you to drink too much or use something that you shouldn't be using too much, such that you're not always in control of the situation. And if that expert determines that you need to receive some treatment, that recommended treatment will become part of your probation. So just making it up, if they say you need to go to one AA meeting or equivalent a week for 6 months, that's going to become part of your probation and you'll need to do that. But if you've got that if you meet with that expert and that person says, you know what, you used to have an issue, but it looks like for the last X months, everything's been okay, I don't recommend any treatment, then you've done what you needed to do by having that evaluation. Any questions about that?
No, sir.
Okay. The final special condition is that you are going to need to spend 4 weekends in jail. You will report to the county jail by 5 p.m. on a Friday, and we'll talk about when this starts, and you'll be released by 5 p.m. on Sunday for 4 consecutive weekends. I am looking at the calendar, and my suggestion is that we start with next Friday, Friday the 14th, and do those 4 consecutive weeks. But I could start it a little bit later, meaning a week later, if you're going to need to move things around. But you've helped me understand that your typical work week is a Monday through Friday. I understand you might need to leave work a little early on those Fridays. And sometimes you work on the weekends, but there will be 4 weekends in a row where you're not going to be working on the weekends because you will be taking care of this final condition of your probation. But before we worry about when those 4 weekends would start, I want to give you and Ms. Watts an opportunity to discuss, because I did change the sentence a little bit. It's 1 more year of probation, although I added the behavioral incentive date. If you're doing well, I think we ought to get out of your way and let you do your thing while Ms. McBee does her own thing. I also switched it to a family violence intervention program, which is a little more extensive counseling and training. And then I added these 4 weekends. Those are non-negotiable. I think that is a reasonable final condition based on what I've heard about this situation, but it's different than what you negotiated for. So I'm going to move you 2 into a breakout room. You should pop back out once you're done talking, and we will figure out if you want to go forward with the plea. If you decide that you don't want to, it will not be shared with the jury that you attempted to enter a guilty plea. But I will expect you to be ready to go to trial in about a week and a half, and that'll take up that week. And if that trial doesn't go well for you, then we'll be talking about a different outcome. But that's something Ms. Watts can talk to you about. And Ms. Nelson, that's just part of my staff, is letting me know it'll probably be a slightly later reporting time on Friday than 5 p.m. I wouldn't worry about that. Frankly, I'll work with your schedule on that. If you said, could you make it 8 p.m.? It's fine. It's the weekend. It just means you get out by about 8 p.m. on Sunday. Before you go into the breakout room, do you have any questions, Mr. Pierce, about what I've described as the sentence I intend to impose?
No, Your Honor.
Ms. Watts, do you have any questions before the 2 of you speak?
No, sir.
Okay, let me put you 2 in a breakout room. Take the time you need, and then and you should know, Mr. Pierce, while you are in there, it's a private conversation. No one can see or hear what, that didn't work well, you all are talking about.
And how do we come back out of the breakout room?
There should be a way to leave it. And if not, I am able to drop in audio only to see what's going on. So if I haven't heard from you all, I will drop in, but there should be a button you can click to get out of there.
Yes,
So there's Mr. Pierce and Ms. Watts, and you guys should get a way to get in there.
I'm gonna head out. Thank you.
All right, Ms. McBee, you said you're going to sign off?
Do I need to stay on? Or
No, ma'am. Ms. Mr. Jordan can let you know what happened.
Thank you. I just have, or I can just transfer my phone, whichever is beneficial.
Okay, however you want to do it. We're gonna give them a few minutes to discuss and then go forward.
Okay, I'll just transfer to my phone.
Okay, thank you.
Thank you.
Take care. While they are talking, are we ready to go with Mr. Fegerland?
We're ready to start getting going. I think we just gotta sign some paperwork.
The waiver,
Okay, they're up there if you want to start filling. You guys can come up to council table. It's easier to spread out there, and you can fill that out. This was position number 1 from, oh, she tracked her down. Okay. Ms. Manson's going to reach out to Ms. Nelson. Huh. All right, good. Wonder if it was the email address. Okay, cool.
So the indictments, was it Tom or Thomas?
Charles, you don't have to hide way in the back in the dark. Okay, you're also welcome to stay back in the dark until we wrap it up. Okay. Is Mr. Fegerland's plea to the indictment as charged, or is it to something different?
to reduce the police sexual battery felony.
Okay, so still a felony plea, but a different felony. Got it.
Mr. Roberts, will it be
Let's keep going down. These are all your rights. The judge is going to want to know that you understand what all your rights are and that you're waiving them and giving them up. We've talked about all this, but it's in the form here. Initially, I'm telling the judge that I understand and agree with them. If I do not understand which statement does not apply, I will not put my initial. So you can read it, right? So initial, go through all that. Okay.
That's an odd one. I've been a sociologist or whatever.
You've spoken with therapists before?
Yeah.
We can tell the judge that if you want to leave that blank and we just explain what it is. Basically, the judge is wanting to see that you're in your right mind to understand what all your rights are. So if you've had some mental health treatment, a lot of people have, it's not a big deal, but we'll let the judge know and then you can initial that. You satisfied with the work of your attorney? Now you get nervous about that one. All right. Have I had enough time to discuss the case with my attorney? And if I know which to enter a plea. go ahead and initial this. If you wish to enter a guilty plea. You can write first offender, just offender. You can comma Alford, ALFORD. Okay, and that's what we talked about. I think that I haven't seen the new accusation you're going to do it, but I think it's just going to be one count. You could just put it a one count sexual battery. Okay, now you're pleading to that, not the child molestation. The two differences, number one is significant, is a child molestation, the sentence can be anywhere from 5 to 20 years. For sexual battery, it can be anywhere from 1 to 5. Okay. And even more importantly, under the sexual offender registry, you don't have to be on it forever with this charge. Okay. While you're on probation, you are. Okay. Your decision to plead is a voluntary decision. You've not been promised anything other than the plea negotiations. Okay.
All right. They are coming back. I see Ms. Watts. Let's put her in the spotlight. Add Mr. Pierce. All right. Ms. Rivers, you ready to go back on the record?
Yeah, read that while we're on the record.
Yes, I'm ready. I couldn't find the button.
That's okay. So we're back on the record in Mr. Kearse's case. Mr. Kearse, did you have enough time to speak privately with Ms. Watts?
Yes, Your Honor.
Okay. Ms. Watts, is Mr. Kearse wanting to go forward with his plea, or does he want to withdraw his plea?
Judge, we're going to move forward.
Okay. Mr. Kearse, tell me the way I ought to structure those 4 weekends so that what I want to avoid is you getting there late or something like that. There are obligations, they're frankly conditions of your probation. So if you don't make it, it's a violation of your probation. And it just gets more complicated because every weekend you miss, I usually add a week instead of a weekend. So you lose 2 and gain 5. So tell me first what weekend we ought to start, and then second, what is a reasonable arrival time?
If we could do the weekend of the 21st,
okay,
and time, I say if we can do maybe 7 p.m.
All right. So you can get there earlier. You cannot get there later. So what the sentence will say is that you will report to the county jail for 4 consecutive weekends, beginning the weekend of April 21st and ending with the weekend of, but including the weekend of May 12th. You need to be there no later than 7 p.m. on each of those 4 Fridays, and you'll be released 48 hours afterwards. If you show up at 6, you'll be released no later than 6. They may let you out Sunday morning, but that's a sheriff processing decision and not a judge decision. So that'll be the final special condition of your probation. Mr. Kearse, do I have your permission to have my staff electronically sign the indictment indicating your first offender plea to the first count of the indictment?
Yes, sir.
Ms. Watts, may we sign for you?
Yes, Judge.
And Mr. Jordan?
Yes, Your Honor.
All right. We have someone from probation here in court, Ms. Tucson. She's going to need to, maybe you could sit at the witness stand if you'd rather do that. But she's going to need to get some information from you or confirm some information, Mr. Kearse. And she's going to give you reporting instructions because you will need to very soon report to the Department of Community Supervision. That's the fancy name for probation. Just so you're plugged in and you know who your probation officer is, okay?
Yes, sir.
Oh, and I just got some intel from the sheriff's office. Your reporting time is going to be 8 p.m. not 7 PM, because it's shift change at 7. And if you show up, that's real complicated for the sheriff's office. So you'll be able to have dinner, and then you need to be at the jail by 8 PM on Friday. Same Fridays, but it's now 8 PM, not 7 PM. Okay.
Yes, sir.
All right. And that'll be written in your final disposition, also known as your sentence. Ms. Watts will be able to get you a copy of that. I don't mean for this to be something that you don't remember. Ms. Tucson, if you could engage with Mr. Pierce about probation.
Okay, Mr. Pierce, what county do you live in?
DeKalb County. DeKalb County.
What city?
I'm in like North Druid Hills, Chamblee. Then between the two.
For DeKalb County, the office is actually in Conyers.
Conyers, okay.
Boy, that's not convenient for a whole lot of people. Why don't they put it the furthest corner of DeKalb County?
They combined a few
Okay.
offices like Rockdale.
It's in Raleigh, North Carolina.
You're right. It's so far. Okay, so may I have your phone number and your address so I can give you a call? I'm going to email you reporting instructions.
Okay.
So that way, what we'll do is have you report straight to the cab. Your report date's gonna be on
We'll leave
April
this.
25th.
I believe we are.
Yes, ma'am.
This time frame. I don't know if you were here earlier when they were talking.
What's your phone
about
number and
the
address?
plea Occurring on.
I can barely hear. I'm hearing 404
With that.
587.
But this is what the
920.
prosecutor.
I hear
Yes.
counsel at council table.
3 years probation.
Oh, hey, Mr. Rousey, I need you to, you're just going through the sound system. So it's making, so let's just wait. It's okay. Let's just wait. We're almost done with this. So, Mr. Pierce, if you could state your phone number again.
404 587 9207.
9207?
Yes, ma'am.
Okay, and your address?
3137 Flowers Road South, Atlanta, Georgia. Unit K 30341.
And even though that's an Atlanta address, you're saying that's actually DeKalb County.
Yes, sir.
Okay.
Okay, I'm going to give you a call, retrieve your email address, and I will send you over reporting instructions. But it will be on April 25th, 2023. Their address to DeKalb, I'll also indicate that, but it's 981 East Freeway Drive in Conyers, Georgia. And failure to report will result in a warrant for your arrest. However, I will get all this information over to you on paper.
Yeah.
Okay, yes, ma'am.
Mr. Pierce, now you still reporting on the 21st. I think that April 25th is what she's referring
For
to.
probation,
For
correct.
Yeah,
probation.
yes. Yeah.
Correct.
Let's not get that confused, okay?
Right.
Okay, yes, ma'am.
Yeah. Thank you, Ms. Watts. That's important. There are two different dates that you actually have 5 different dates. You've got the April 21st is the first of your 4 weekends in custody. April 25th is when you will hoof it way out to Conyers to meet with probation, meet your probation officer, get all that set up. I've been advised, and it's very good advice, that you should bring with you, Mr. Pierce, when you report to the jail each time, a copy of your final disposition. That's your sentence. I will sign that later today. It'll be e-filed and Ms. Watts will be able to get it. But my staff reminded me that we have had defendants show up at the jail saying, the judge told me to be here. It's a condition of my sentence. And the jail's like, we're not a hotel. You can't just check in here. They need proof that that's actually part of your sentence. And the best way to do that is to have your sentence with you. And they'll look at it and say, oh, look at that, 4 weekends, the 21st, the 28th, May, whatever it is. So please try to remember to have with you your final disposition. That's the technical name for your sentence. Ms. Watts will get that to you once it's been e-filed later today. Okay?
Yes, sir.
Ms. Watts, any other questions or anything else on behalf of Mr. Pierce?
No, Judge, not at this time.
Okay, thank you for working with Mr. Jordan so we could take care of this in advance of next week, which is going to be busy for everyone. Mr. Jordan, anything else on behalf of the state?
Nothing further from the state, Judge.
Okay, you or Ms. Clark will reach out to Ms. McBee if she's not still on to let her know the outcome.
Absolutely, Your Honor.
Okay, I appreciate it. All right, Mr. Pierce, you are free to go. And thank you, Ms. Watts. You're also free to go.
Yes, sir. Judge, just before we leave, may I have that number for the probation officer?
Sure.
404
404
308
308
7618.
7618.
Thank you, Judge.
You bet. All right. Bye-bye.
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 That concludes my business, Your Honor. May I please be excused?
You may. Let me just ask you one question. Oh, you don't have none of the Quentin McCoy you have. That's all Ms. Willingham.
Yes, Your Honor, that's correct.
Okay. Does it sound like Michael Palmer is going to work out?
He pled a few weeks ago.
Oh, he did?
Ed Adams was his.
Yeah, that's right. Okay, done. Because I remember him from drug court. So I saw that like, what's happening with that? The answer is it's pled. Great. Well done. 2 cases. See ya.
Thank you, Your Honor.
I'm going to run downstairs to print out the little packet for SPS.
Okay, great. It'll take a little while with Mr. Fegerland anyway. Mr. Rousey, do you and Mr. Fegerland need a little more time with the form?
No, I do have 1 or 2 questions for the court in terms of a response to paragraph number 7. Mr. Fegerland has had some mental health treatment.
So then he shouldn't, he should initial it if the answer is I have not. If he has, that's just an indicator to me to make sure I engage with him on that topic. If you don't bring it up, just so no one slips by and we realize, wait a minute, this guy shouldn't have been taking a plea. That's not your client. But I want to understand what
we left it uninitialed.
Good.
And then the other one, hearing the earlier proceeding, I believe that we are entering this plea occurring on or before the final plea date, but maybe not. I just wanted to be
right. I think not. That form is older. It's accurate other than it says final plea, which is what we have begun renaming our status calendars. Our status calendars are the unfortunate name I gave what used to be final plea. I got frustrated because at final plea, there were never any pleas. Like, I'm not going to call it that anymore. Because really all I was getting was a status update on the case. I don't have discovery. We haven't done this.
And that's what our last appearance was with regards to. No, well, the last appearance, we argued a motion.
You did. I'm getting Mr. Fegerland's case up here to see its trajectory. So were you all not here on the 17th? The 24th of February is when we argued the motion, the child hearsay, et cetera. I entered my order on the 13th of March. And then on the 17th of March was the status conference, formerly known as final plea. And what it says here is continued, but continued probably means continued to a trial calendar.
I think it was continued to do the plea because Mr. Fegerland lives out of state.
Okay.
I had talked with Mr. Shapiro about the logistics because of the probation conditions that he's going to be on and where he was working at the time. He had to finish up work.
Okay.
And that was my understanding. It was our intention to let the court know we accept, we want the plea.
Got it. So the plan was to, if logistics didn't get in the way, it would have been a plea on the 17th.
Correct.
but there were reasons why it couldn't. So yes, then Mr. Fagerland's final plea rights still apply.
Okay.
So if I go nuclear in this situation and say 1,000 years to serve, Mr. Fagerland can say, I'll go to trial instead.
So we'll leave that option open.
Yes.
And I believe that was all the questions that I had from a housekeeping on this plea sheet.
Okay, then let's get on the record. Ms. Rivers, you ready?
I'm ready.
Great. This is position 25 from the trial calendar, State versus Thomas Fegerland, 22 SC 184340. In the indictment, Mr. Fegerland is charged with child molestation. It sounds like the state is reducing that to sexual battery felony, but I'll let Ms. Charles navigate us through all that. Mr. Fegerland is here in court with his lawyer, Mr. Rousey. And as I just said, Ms. Charles is the representative for the state for the purposes of this plea. Mr. Fegerland, in a moment, Ms. Charles is going to put you under oath. I'm going to ask you all to come to the podium, if that's all right. Once you're under oath, Mr. Fegerland, it's important that you answer all questions truthfully and completely. Also important that if you've got questions of your own, you let me know that. So either I can try to answer them, or you and Mr. Rousey can take a break and speak privately if you need to do that. Will you do that for me?
Yes, Your Honor.
Okay, Ms. Charles.
Thank you, Your Honor. Mr. Fegerland, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. Thank you. Please state your true, correct, and legal name.
Thomas Robert Fegerland.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication you normally take that you have not taken today?
No.
How old are you?
47.
How far have you gone in school?
Master's degree.
Are you able to read, write, and understand the English language?
I am.
And do you understand that you're being charged with the following offense in indictment 22 SC 184340, sexual battery felony pursuant to OCGA 16622(1), subsection D, which is a reduction from the original charge of child molestation pursuant to OCGA 1664A.
I understand.
Do you understand you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
I understand.
Have you reviewed the waiver of rights form with your attorney?
Yes, I have.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
I do not.
Are you satisfied with his services?
I am.
Counselor, do you waive formal reading of the indictment?
Yes, we do.
Do you waive any and all defects in the indictment for purposes of this plea?
Yes.
Mr. Fegerland, do you remember being arrested on this charge?
Yes.
The state is unaware of any outstanding warrants related to this charge. Do you or your attorney know of any outstanding warrants related to this charge?
I do not.
I'm unaware of any outstanding charges also.
Thank you. Sir, has your attorney advised you of the minimum and maximum sentence for the charge you are pleading to today?
He has.
For the record, the charge of sexual battery felony, the minimum would be 1 year and the maximum would be 5 years where the child was under the age of 16. Do you understand that this is a negotiated plea of guilty, which means the state will make a recommendation to the court. However, the court does not have to accept this recommendation.
I understand.
The negotiated recommendation is as follows. 3 years probation with the following special conditions. First condition, that you'll be subject to the state's sex offender registry. The second condition, you will have no further contact with the victim, Lennon Pastor, Lennon Pastore, or any of her family members. You will submit to a psychosexual evaluation and follow all recommended treatment. You will not be employed in any professional capacity involving the supervision of minor children, and you will submit to the Fourth Amendment waiver.
Are those the conditions you understood them to be?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
I understand.
Do you understand that if you're pleading guilty to a crime against a minor or to conduct of a sexual nature involving a minor, as defined by state law, you will be required to register as a sex offender?
I understand.
Are you a US citizen?
Yes.
Do you understand that there may be adverse or unfavorable consequences as a result of your guilty plea, just as there would be following a conviction after a trial?
Yes.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you also understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
I understand.
Mr. Fegerland, are you being asked to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your attorney explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you would be adjudicated guilty?
I understand.
And you could also be resentenced up to the maximum sentence for the charge in this indictment.
Understood.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
I understand.
Do you understand that by pleading guilty, therefore, you are giving up the following rights? The right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assistance of counsel hired by you or to court-appointed counsel,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
and the right to have the charges against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of this charge after a trial.
Understood.
Mr. Fegerland, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yeah, you can enter yes.
I will enter yes.
Say that again?
You can say yes.
Yes.
Okay.
Is it my understanding that you intended to plead guilty under the Alford, pursuant to North Carolina v. Alford?
Yes.
So we're going to ask that question one more time. Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
So here's what we're navigating. It's not meant to be a trick question. You're not going to, the floor doesn't open up if you answer it the wrong way. Mr. Fegerland, there's 3 scenarios we could go through right now. You could say, I didn't do it, I want a trial. Okay, we just spun our wheels for nothing, and I'll see you next week. Number 2 is, I did it. You can say I feel terrible or not, but I did it. as in, I'm guilty, I did all the things the state said. Or, and this is where I think we're heading, I don't agree with everything the state said. You got the right guy, but I don't agree that the state could prove all the things that you know they're about to tell me about, because they're going to tell me the allegations in the case. But I, meaning you, Mr. Fegerland, think it's in my best interest to go forward with this plea. It's a best interest plea. That's what we call it in quotations, but it's also called an Alford plea because there is an old US Supreme Court case that has authorized trial court judges, someone like myself, to actually take a plea, even though a defendant says either I didn't do any of it or it didn't go down like the state says it went down, but I don't want to run the risk of going to trial and the jury looks at this in a way that I disagree with, but they find me guilty, of course, of child molestation, because that's what the trial would be about and not sexual battery. So it's either I didn't do it, I want to go to trial, I did it 100%, or it's in my best interest to enter this plea, and my lawyer is going to explain why it's an Alford plea, and that's how I want to go forward. Which one of those three is it?
It's in my best interest to enter an Alford plea.
Okay, we can do that.
And are you pleading guilty because you have decided it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
I am.
Mr. Fagan, how do you plead to the charge of sexual battery felony in indictment 22 SC 184340?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of all of the charge against you?
It is.
Do you understand you only have a limited right to appeal this guilty plea conviction?
I understand.
Do you understand you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I understand.
Your Honor, the state is unaware of any prior felony convictions for Mr. Fegerland. However, had this case proceeded to trial, the state would have expected to show that on September 7th of 2020, officers of Milton PD were dispatched to 530 Hopewell, Hopewell Downs Drive, which is in Milton, Georgia, 3004, to investigate a report of a sexual battery against a 9-year-old, Lennon Pastor. On arrival, officers met the mother of the minor, Miss Lucy Pastor, who we believe is observing via Zoom today.
I've seen the name on there.
Yes, and stated that Mr. Fegerland was a family friend who had sexually assaulted her 9-year-old daughter. She identified the suspect as Mr. Thomas Fegerland, stated he had lived in the family's basement for a while because he was sort of in between housing. He had just sort of purchased a house and was sort of hadn't just quite moved out yet. At the time, Mr. Fegerland was employed at the Capstone Academy in DeKalb County, where Miss Pastor's daughter attends school. Miss Pastor reported that they had been sort of drinking and sort of hanging out a little bit, and then everybody sort of went to bed. The following morning, Lennon Pastor explained that while she was in bed, the defendant came up to her bed, sat next to her, and then touched her inappropriately under her pajamas towards her buttocks and sort of towards the top of her buttocks. The minor Miss Pastor explained that when she woke up, she went to school as normal. However, Mr. Fegerland advised her not to say anything to anyone, particularly not to say anything to anyone at the school. When officers spoke to the defendant, he admitted to putting her to bed. He admitted to putting his hand on her lower back. He admitted to rubbing her back, saying that they had asked, or she had asked for a back rub. He did not admit to doing it inappropriately. And he said, if it appeared to be inappropriate, it may have been an unconscious act, but he disagreed with the fact that it would have been motivated by anything sexual. Evidence would have shown that there were multiple sleepovers that involved Mr. Fegerland and the family, Miss Pastor. The evidence would have also shown that the mother, Lucy Pastor, was listed as the emergency contact in Mr. Fegerland's employment sort of intake form. There was a relationship that was described between them as complicated. And
In the week following the outcry, Mr. Fegerland was allowed by Ms. Pastor to drive Lennon back and forth to school. And then a week later, the report was made. And so all of that was taken into consideration when this plea was negotiated. I understand Ms. Lucy Pastor may not be completely in agreement with how we have, the state has resolved this case, but we think based on the evidence in the case, there was mention by Ms. Lennon Pastor when the hand was placed on her upper buttocks, it wasn't moving, but it was present. And so the defendant has decided this is in his best interest to go ahead and take the plea. And we think that as presented, this is the best for all concerned.
Okay, so I'm following it. Mr. Fegerland was an invited guest in the Pastor household. He worked at the school where the victim was a pupil. And so he, Mr. Fegerland, at times actually drove the victim to school because he worked there, and what a convenient thing for the mother. Her daughter is getting a ride to school with someone who works at the school and someone who up to a certain point in time she trusted.
Correct.
Understood. Okay. So the victim is now, I guess, 11-ish, will be 12 later this year. Okay. I think that, do you know what Mr. Fegerland did at Capstone when he worked there? I can find out probably from right here. Okay, I'll find that out when I turn to Mr. Rousey. Thank you for that information. Does Ms. Pastor want to say anything, or she is going to merely observe?
Also, she would just be observing.
Okay.
I would love to say something.
You do?
I would love to.
Okay, then I need you to unmute and invisible so I can see you and hear you. And it is perfectly appropriate for you to share with me, and just know that you and I are having the conversation. It's not for you and Mr. Fegerland to have a conversation, but I would like to hear from you what you want to share about this situation, impact it's had on your daughter or you, and what you think ought to happen as a result.
Yeah, I'm just working on getting the video on. Bear with me, please.
Okay.
All right. Enable cameras access. All right, it's telling me to enable the cameras access in my address bar. Learn more. I need your help. Any advice?
Are you on a phone or a computer?
I'm on a computer.
Let me see if this helps. Did something just come on your screen?
Yes, it did. It just keeps telling me to enable camera access in my browser's address bar.
Well, how about this? Do you recognize that voice, Mr. Fegerland, to be Ms. Pastor?
I do.
Okay, then why don't you just tell us, let's not worry about the technical piece. And why don't you, Ms. Pastor, share with me what you wanted to share?
Yeah, I just wanted to start with that the moment that my daughter told me what happened with Tom, there was no more contact. He did not continue to drive her to school for a week after that. That did not happen whatsoever. In fact, after my daughter told me what happened, it was kind of a tailspin. Her dad and I went to the school, checked her out early and was like, hey, what happened? And we got the lay of the land. And then later that day, Tom had sent me a text message, which the prosecutor and probably the defendant has, saying, your family's my family and all those things like that. Now, that being said, I just wanted to state that certainly there was no contact whatsoever on our behalf with my children, any of my children or myself, since that morning when me and my daughter confronted Tom about what happened. That being said,
so before you go further, I must have heard it differently than you did. What I heard Ms. Charles say is that it actually was several days before the outcry was made. And so, and I'm making the dates up, but if the incident was on day one, okay, there were a few days when Mr. Fegerland continued to take your daughter to school because you didn't know about this because she hadn't said anything. But once your daughter made the outcry, whether it was to you or someone at school, then all contact was off. So I think you two are saying the same thing.
No,
Ms.
no. With all due respect, we're not. The morning that she told me, we were all in disarray. Like even Tom, you know, I was trying to tell him, and he's like, no, that didn't happen. And they did go to school that morning. And I went and I told their father what had happened. And we got in the car and we went right to Capstone and we checked her out of school. And that was the last time ever any contact or anything on our behalf with the kids. So that was it. There wasn't multiple days that went on, but after that so now the disconnect probably is, this is with what you're probably seeing, Your Honor, is that it took a few days for us all to process because this is new territory for us. And we wanted to get the full story and make sure our daughter was okay. And then I went to the head of school and I said, this is what happened over Labor Day weekend. And he said, have you contacted the authorities? And I said, no. And he said, that's the first thing you need to do. And that's probably maybe the delay that they're thinking about. But there was no, he did not take my daughter. He never has been around my kids since that day.
Okay. And what you're sharing with me is that your daughter shared with you the morning after the incident, or she
Correct.
shared with you a few days later?
No, the morning after, the morning, like 6 a.m. in the morning. She said, I need to tell you something that Mr. Tom did.
Okay, got it. So now I better understand, and you've cleared that up. I of course am much more focused on what happened that night and not what followed. So I was not at any point thinking, what kind of mom is this who left her daughter with Mr. Fegerland? But I appreciate why you're focused on it. I was not focused on that. It would be uncharted territory for anyone. It's difficult to process. Parents should never have to go through something like that. You have. One thing I'd like to hear is how your daughter is doing, but I want you to share with me all the things you wanted to share.
You know, it's been traumatic. Like, to your point, it happened almost 3 years ago and she's about to be 12 in a couple of months. So there's been a long gap between everything that's happened. My daughters will not speak his name. If they ever bring it up, they spell it out, Tom, because of the events that happened. There's been therapy that had to be introduced to my kids' lives. We thought he was a trusted family member. You know, I say family member in quotations, someone that I've known since 2006 that I had obviously trusted. And it's been a hard road. It's been a long road, and we're finally to this date, and it's just kind of rocking my world a little bit, because I have to look at my daughters and they want to know, did Mr. Tom, you know, or TOM, did he go to jail? Did he? And I said, baby, I know it happened almost 3 years ago and I still don't have an answer for you, but I'm proud of you for what you told me, because my daughter, like I said, Your Honor, told me that morning at that instant. And that's what I focused on with her. And I said, I am so proud of you for telling me this. And I'm so glad you did, because you saved yourself and your sisters and somebody else from something else that he might have done in the future further from what you're even telling me. And it's just been, it's been a battle, you know, through all of this. Her father and I have divorced. I mean, it's been a situation that has had impacts on our family that nobody would have thought. And it's so hard. And I can't have my daughter on this Zoom call today, because I don't want her to see him. I don't want her to relive everything that happened almost 3 years ago. So it has been so difficult to be able to tell my daughter, I have 3 daughters, but my oldest is 2, that understand what happened, that we still don't know what's happened, and that there's been no punishment. And he's been out in the wild for the last 2.5+ years doing God knows what, under God knows what circumstances. So that's the hell that we've been living in because of Tom Fegerland's poor decisions that he continuously makes over and over and over and over again.
All right. Well, I'm not cutting you off. I'm not sure if you are taking a deep breath and there's more you want to say, or if you have shared with me, I think very powerfully, the impact this has had on your daughters, as well as you.
Yeah. Yes. Yeah. I think that's, there's nothing else I can say. We've been living in purgatory.
Have you had any unwanted communications from Mr. Fegerland since this happened? You described it as you cut yourselves off from him, and your kids will spell his first name and that's it. But has there been any instance when Mr. Fegerland was trying to contact you and after all this happened?
No, just the afternoon after we picked her up from school and talked to her, and he just sent that text message, and I never responded to him, and I have not heard anything from him since.
Okay, well, that's a start. That's a good situation. Okay, now how many daughters do you have?
3.
All right, and as far as you understand it, it just involves Lennon, this situation.
It involves her from the physical aspect, but from the mental aspect, her older sister, who is now 9, Olive, was in the bed next to her, and she knew that something had happened because Lennon had said it in front of her, and by nature, she's a very curious child and wanted to know, and she just knew that something inappropriate happened, but she was asleep when it happened next to Lennon.
Right. I said that in a poor way. I don't mean this has not affected everyone, but in terms of these allegations, it involves simply Lennon and not any of your other children.
Correct.
Okay. All right. Well, Ms. Pastor, I know that was not easy to share. It may, as you reflect on it later, have been helpful for you to get that out. And I always appreciate hearing from some member of the victim's family, because I always hear from the defendant if he or she wants to be heard, and always from a defense attorney and from the prosecutor. But Ms. Charles is one step removed. She didn't live through what you and your children did. So it's helpful for me to hear sort of at that gut level that this is more than just an indictment with some words on it, but there are real people involved on both sides.
Thank you for saying that.
You're very welcome. All right, I'm gonna, if you don't have anything else you want to share, I'm gonna move on to the next folks I need to hear from. Are you okay right now with me doing that?
Yes, sir.
Okay, thank you. All right, Ms. Jackson, can you share with me the criminal history you have for Mr. Fegerland?
He does not have any prior arrests on file, Your Honor.
So this is it. Thank you. All right, Mr. Rousey.
Yes, Judge. I guess I'll start by saying Mr. Fegerland came to me shortly after he got a call from an investigating officer. He's been nothing but cooperative throughout the process. I think he initially went down prior to meeting with me and spoke with the officers and gave his statement. And you've heard Madam Prosecutor describe that. The sequence of events that Ms. Pastor and Ms. Charles had referenced, I think, have been cleared up. There was an alleged reporting or outcry the morning of, and confrontation, as I understand it through watching the videos, the body cam officer who came out to the house the following, I believe it was Monday. This might have been a Thursday. Apparently.
Oh, that would fit the Labor Day. We heard about it being Labor Day and whatnot.
Yes. So maybe it could have been Tuesday or Monday or whatever it was, but there was the outcry. I think there was a discussion or confrontation between Ms. Pastor, the mother, and Mr. Fegerland. And Mr. Fegerland subsequently took the alleged victim to school. And at school, I think Mr. Fegerland, as much as anybody, was also alarmed and concerned about the allegations, the sensitive nature of all of this, and has said something to her about, don't say anything to anybody. This could be problematic or otherwise. Whether that's a consciousness of guilt or what the state would produce at trial or otherwise, I do think that the negotiated plea is in the interest of justice with all involved. I do think this would have been a very difficult trial proceeding for not only Mr. Fegerland to go through, but the Pastor family also.
Well, it sounds like it. I mean, one of the helpful things to hear from Ms. Pastor is that her family's still struggling with this, and it will not allow wounds to continue to heal if Lennon has to take the stand and
I
talk
think-
about it.
I think my job would have been very difficult and I would have pointed out some things about the family and the circumstances, the complicated nature of the relationship between Mr. Fegerland, Ms. Pastor, family issues. I don't know whether the court would have allowed me to introduce. It was something I was contemplating if we went to trial about Ms. Pastor's past and issues that could have contributed to, not we're
But
here.
we don't need to go there
recognizing
now.
That it is in Mr. Fegerland's best interest to enter this plea to the terms and conditions that we've negotiated with the state. The actual allegation, Judge, and Ms. Charles had made reference to it. I think the state may have been in a difficult position too, with regards to assuming the facts as the state presents them to be true.
There's a difference between a back rub, and I recently had to work through the molestation statute with a pro se defendant where the allegations are very clearly in the center of what would constitute child molestation. This is, I think, literally and figuratively sort of at the edge and would be complicated.
It would be complicated. And quite honestly, when I anticipated initial charges to be sexual battery, but then when I looked closely at the statute, I was like, well, sexual battery, did he actually touch her buttocks? And part of the reason I want to see that video in the interview was the description and the reports that I read. It doesn't quite reach the level of going to the buttocks. Maybe it does, definition, so on and so forth.
Jury question.
And then when I talked with Mr. Fegerland about this, the charge of molestation, you don't even need contact. It's just the inappropriate suggestion. And then you get into the mind of individuals and all that. So it would have been a mess at trial. So given the fact that Mr. Fegerland has no criminal history, he's 47 years old. He was with this family for several years, acting as a nanny, as I understand it. And that the family was invited to his house. I don't know if the court was clear on that or otherwise. My understanding is that this incident allegedly occurred at Mr. Fegerland's home, where Ms. Pastor and the girls were staying with him that night.
No, I didn't. I mean, it's not going to change how
Oh,
I
no, I
handle
know.
this, and
But
I
that's-
don't want there to be a back and forth, and then Ms.
No, I
Pastor
don't either,
thinking
Judge,
she.
but I did, in interest of letting Mr. Fegerland be heard and his side of the equation, that this could have been a difficult trial for all involved. But he does recognize that this is a very dangerous charge, the serious nature of it. And I'll let Ms. Pastor know that Mr. Fegerland has been under bond conditions that he has abided by during and since his arrest that have been onerous. And that was part of Mr. Shapiro's and I's discussion, that he's been under those conditions since his arrest and why we've arrived at the negotiated plea that we have.
Okay. Mr. Fegerland, is there anything you want to add? Or has Mr. Rousey covered it?
Mr. Rousey's covered it, sir.
Okay. Mr. Fegerland, what was your job at Capstone Academy back in the late summer of 2020?
Was the associate head of school.
And Capstone Academy is what grade range?
To start the year, it was 5th through 12th, and then we added a 4th grade.
Are you working now?
I'm self-employed.
What do you do?
Construction labor and landscaping.
And that's not in Georgia?
That's correct.
Mr. Rousey, how is probation going to work for Mr. Fegerland? Because it can't start in North Carolina.
Well, I guess that was part of the questions. I tried to catch up with Mr. Shapiro. I know he's a busy man, and why Mr. Fegerland is here today. We're entering this plea in person. My understanding is the probation would transfer to Tennessee. He lives in Tennessee with his mother and father. Is it your father or both are ailing and you're both? Okay, so he's got aging parents that he is taking care of. And that's where he's living.
So probation can transfer. It is the receiving state's option as to whether they will take the supervision. So Georgia doesn't get to export, but it can be imported. The nature of the charge can influence that decision. But regardless of whether it's acceptance or rejection, it's not instantaneous. So we'll need to figure that out. And I suspect you've had clients go through this before, but if you told Mr. Fegerland, hey, this is great, you can go back and stay in Tennessee, I don't think that's how Georgia probation is going to view it. I think he's going to need to be here until he can be somewhere else.
I think he has to just register there in Tennessee, and their department will get in touch with. The most recent one I had, somebody had to go out to Colorado, and they contacted the court here and imposed the conditions. And you're right, Your Honor, they have to sort of accept it, and they'll be. And I've talked with Mr. Fegerland about that. I've tried to read Tennessee's statute. I'm not a Tennessee licensed lawyer, but it seems that they have a very similar reporting registry and all of that he would be required to abide by.
Okay, and I was less focused on the registry. There are registries in every state, and certainly and we'll talk about registering in a little bit. I was focused more on probation, and I've never heard of a scenario where a defendant gets to kick off probation in another state. It's that you start in Georgia. Even if you're a resident of that other state, your probation starts here and gets transferred to the receiving state here, Tennessee, assuming that state accepts it, but there's a fee that has to be paid and paperwork that has to be sent across. I'm going to let our subject matter expert talk about that. But Mr. Fegerland, you need to understand going into this, it may not work exactly the way Mr. Rousey had described to you. Okay?
In what respects, Judge?
I don't know that Mr. Fegerland can go home right away. But let's get there in a minute, because he doesn't have another option. I mean, the other option would be go to trial. And if he's found guilty in the end, then none of that. This is his most flexible option.
Right.
So let me continue with some of the other things, and then we'll engage Ms. Toussaint on that. Mr. Fegerland, an offered plea, which is what you're trying to enter, this best interest plea, is something I can accept. I need you to understand, and you to acknowledge that you understand that that's still a conviction. So it's not like a NOLO. It would show up if someone runs your criminal history, who has the authorization to run your criminal history. This shows up as a conviction. There's not a special light that goes off that says, well, he didn't really do it, so you shouldn't take it seriously. Do you understand that?
I understand.
Okay. I find there's a factual basis for your plea. And by saying that, all I mean is that I find that a jury could find you guilty based on the factual basis that Ms. Charles provided. Not that the jury would, but the jury could. I need to be comfortable that the state could prove its case. Mr. Rousey has identified a bunch of reasons why a jury might struggle. It may be a hung jury. It may be a jury would say not guilty, but a jury could find you guilty. And I would sustain that verdict if the jury did find you guilty, assuming the evidence played out more or less along the lines of what Ms. Charles said, which would ultimately boil down to 99% of it, what young Lennon said in her outcries, and then the confirmation of those witnesses. And you sat through the hearing we had about the child hearsay, and I explained in my order how that would all come in at trial, assuming Lennon was made available to testify. Mr. Shapiro had made very clear she would be testifying if this case went forward. I also understand why it's in her interest not to have the case go forward, so that she doesn't have to come in front of 14 strangers talk about the situation that has clearly been difficult for her, her sister, and her mother to process. But I do find there's a factual basis. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, and knowing means you've understood everything we've been talking about, except maybe this piece about probation. Is that a fair statement?
Yes.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which in Georgia would mean that if you have a small or technical violation, then probation would work through that. But if it's a more serious violation, a new arrest, or a violation of one of your special conditions, that will come back to me. That whole Probation Options Management Act may not apply in another state. If you end up in Tennessee, it may be that any violation goes to a judge there. I don't know. It also may be that they just kick it back to Georgia if there's a violation. Best thing would be don't violate your probation. Do you authorize my staff to sign the indictment indicating your plea to the sexual battery charge?
I do.
Mr. Rousey, can we sign on your behalf?
Sure.
And Ms. Charles?
Yes, Your Honor.
All right, we'll take care of that. Mr. Fegerland, whether you're in Georgia or Tennessee, or I think any of the 50 states of the United States, you'd be required to register as a sex offender because of this plea. Do you understand that?
Yes.
In Georgia, I can't speak to Tennessee law, but I bet it's real similar. In Georgia, being a registered sex offender impacts where you can live and where you can work. You understand that that is a consequence of being a registered sex offender.
Yes.
In particular, where you live cannot be too close to a school or a church or a playground or a park, and you would not be able to work in this kind of job you had before. Construction would be fine as long as you're not building a house right next to a school, but you certainly could not work in early childhood education or be a counselor at a school or run a daycare center. You understand that?
Yes.
I'm guessing, but I'm only guessing, that Tennessee's restrictions are similar.
They are.
Okay. So, given all that, I will follow the joint recommendation as it has been negotiated and sentence you to the charge of sexual battery to a term of 3 years probation. You will be required to register here in Georgia and or in Tennessee. I don't know where you'll first have to register, but wherever it is you're living, you'll need to register on the sex offender registry of that jurisdiction. You shall have no contact, direct or indirect, with anyone in the Pastor family. Sounds like that's been the way you've been living your life for the last almost 2.5 years. Just maintain that. You also will need to submit to a psychosexual evaluation. If that evaluation yields any recommended treatment, that treatment will become a special condition of your probation. And finally, although I think this will be a requirement of whatever registry you're on, but I'll bake it into the conditions of your probation, you may not hold any employment that would involve you supervising, counseling, being responsible for anyone under 17 years of age. Okay?
Yes.
Understood. First of all, did I miss any of the conditions of probation, Ms. Charles?
Just a supplemental waiver, Your Honor.
And this is what I went to get, the conditions for SPS that you have to sign, that all this is on here, Mr. Attorney.
Okay, they'll work through that, but that's the Fourth Amendment waiver, all that kind of stuff, and that's standard. Mr. Rousey, anything about the sentence I imposed you have questions about, other than we're going to talk about residents?
I do not, Judge. I didn't know.
I'd like that, if we can, I'll take that,
Okay.
please. Mr. Fegerland, Mr. Rousey is handing me the form entitled Plea of Guilty. This is the form you and Mr. Rousey went over, and there is a place on page 4 for signatures. Is that your signature?
Yes.
And Mr. Rousey, you signed it on page 5.
Yes.
This reminds me, Mr. Fegerland, you did not initial next to paragraph 7A. That statement is, I have not received mental health treatment in the past 10 years. By initialing there, that is your way, by not initialing there, that is your way of saying, I met with a counselor or a psychologist or a psychiatrist at some point in the last 10 years. Tell me a little bit about what that situation is so I can be comfortable. I'm not missing any issue about your ability to meaningfully enter this guilty plea.
Your Honor, many years ago, probably 7, I worked with a social worker to help with some depression.
Okay. Were you prescribed any medication at that time?
We did a 6-week trial and decided it wasn't useful.
Okay, and this was more than 5 years ago and multiple years before this situation?
Yes, on both accounts.
Okay. Since then, no treatment with anyone who would be in a position to recommend any mental health regimen?
No, Your Honor.
Okay. That is all I needed to cover other than the probation piece. Ms. Charles, anything else on behalf of the state?
No, Your Honor.
All right, Ms. Tucson, what do you need from Mr. Fegerland and what is the situation? We have a Tennessee resident here. He's not a Georgia resident. So that's a little different than when we have a scenario where someone says, hey, I live in Atlanta right now, but I really want to move to get out of here and I want my probation to follow me.
Well, two things.
You may need to be near a microphone so we can get this on the record. Oh, don't say anything more till you're at a microphone.
Okay, you can't leave the state. Your attorney's gonna have to go over the special conditions of probation because you will be placed on the SBS unit. You'll have to get approval. It's called ICOTS, Interstate Compact. And there are, once you report, they're gonna to Atlanta, usually reporting's to about 10 days, but you'll have to report right away on Wednesday with all of your paperwork. And you'll have to find you, once you're gonna be, after this is done, you're gonna be on full-time probation. So you can't leave the state until you're approved by probation because they will issue a warrant.
So that's my recollection of how it works. There are a few ways to amend that approach through judicial intervention. I believe I could authorize a different address. Are there ways, let me explore two areas.
Even a little more of a difficult case because it is SPS.
I agree. And
Not
that,
a regular transfer or,
right.
There's stipulations here in Georgia and in whatever state you're going to.
Right, in Tennessee. If I wait to sign the final disposition until we hear from Mr. Rousey that Mr. Fegerland's got all the paperwork and the money and everything he'd need, and we get a specific reporting date for probation, that would minimize the front end. In other words, if I don't sign the final disposition, Mr. Fegerland can go home today because he's not under sentence. But I'm wondering if there's a way that once we know what his reporting date is, that could be when he needs to be in Georgia because he's not reporting tomorrow. Is that correct?
Correct. It will be on Wednesday.
Next Wednesday.
Correct.
Okay,
It will
so
be, Wednesday at 10 a.m. because the SPS, the new cases, they have to be there at a certain time because that's when those two supervising officers are there to do the intakes.
Okay.
Are on Wednesdays at 10 a.m.
Got it. So on Wednesday, the 12th, at 10 a.m., Mr. Fegerland needs to be on Memorial Drive, introducing himself to probation.
Correct. I will need to forward them information, of course, prior to that with police report,
Yep.
everything like that.
Got it. Let's do this. Mr. Fegerland, you're going to need to be back here next Wednesday at 10 a.m. Between now and then, I'm authorizing you to go back home. You won't be invited. You won't have a warrant taken out because you really won't have engaged the probation process until then. Between now and then, you and Mr. Rousey need to work with probation to figure out all the parameters. Ms. Tucson has shared with you exactly how I understand it to work, that actually folks are Georgia based until the receiving state says, okay. You and Mr. Rousey need to figure out how long that process might take, what the steps are in that process. And then if it is not economically or medically, and not your medical situation, but your family, your parents' medical situation, feasible for you to be based in Georgia while that's happening, then we'll need to explore whether I can enter an order that authorizes, in other words, it protects probation from any liability if you're in Tennessee while you're waiting for the transfer of supervision to occur. I'm open to that with certain conditions where you're reporting regularly, at least telephonically. But I don't know how those logistics work, and it's not my job to figure them out. But the guy you pay, he'll need to figure it out. Hope you pay him. Figure out how that's going to work. And you've got some days, you've got a week, because it's Wednesday and that's next Wednesday. So you've got a window to work some of that out. But I can tell you, you will need to be back in Georgia at the address that Ms. Toussaint's going to give you at 10 a.m. next Wednesday. Because if you're not, they issue a warrant and it all goes downhill from there. What happens after that is sort of a TBD. Let's see what Mr. Rousey can find out on your behalf. He will work with my staff and with Ms. Toussaint, and the prosecution will be kept in the loop. They got the sentence they asked for, so I don't think they're going to get in the way of this, but I may need to engage a little bit if I decide that it is impractical for you to be in Georgia the whole time of that waiting period. But I actually have much less authority after you've been sentenced. It may be that Department of Community Supervision says, that's fascinating, Judge, but you actually don't get to tell us how to do our business. Those are the kinds of things Mr. Rousey can find out. Generally, where there is a will, there is a way, and we'll see what we can figure out. What did you want to add, Ms. Toussaint?
Usually with ICOTS, when they do report, they would have, or will already be expecting, they're anticipating, okay, this person is an ICOTS. However, it's still going to take a few days with them receiving the money order, all the information, they have to confirm receipt, and then you more than likely are still gonna have to be somewhere in Georgia for a few days.
Sure. I think that's what Mr. Rousey is going to learn, that we've described two different scenarios. One is you're here from next Wednesday at 10 a.m. until who knows when. That's worst case scenario. And that's the one that I think might end up being impractical. And here I'm thinking more about your parents than you. The other scenario is you have a 3-4 day vacation in Atlanta. I'm joking when I say vacation, but you actually would have to be here regardless of my perspective on it, while all of this registration and getting you in the system. To me, that's manageable. If what is reported back to me is that you might need to be in Atlanta for 2 or 3 days, and Mr. Rousey says, please don't make that happen either, just to manage your expectations, I'll probably say that's one you're going to need to eat and figure out where you can stay for a few days. As long as it is a few days, if a few days turns into a few weeks, then I intervene and say, that's not what was represented to me. Mr. Fegerland is going to go back to Tennessee. I'm not signing any warrants for him because it didn't take 2 days. Someone's saying now it's going to take 2 weeks. So I think that's where Mr. Rousey can engage and educate, not Ms. Toussaint, but me, as to where it might be appropriate to intervene.
I'll get in touch with Ms. Toussaint
Yes,
immediately.
I have information right here on this paper, his name, docket number, and you have to go over these conditions before we leave, and then I'm gonna hand them to Judge.
Okay.
It's everything for that, so.
Great. All right. Any other questions, Mr. Rousey? It sounds like you'll do some due diligence here and let Mr. Fegerland know, but you're on notice that it is highly, highly likely that you'll be here in Georgia for a few days after the 12th. And Mr. Rousey will try to figure out as best he can, is that 2 days? Is it 3 days? But that'll be a little flexible. And then my hope is once that first step of the process has occurred, with my authorization, which I'm prepared to give, you can get back home to your parents and your job, and frankly, away from the pastors. I'm assuming they're still in the metro Atlanta area, and it's better for them if you're in Tennessee. And we'll work it that way.
Thank you, Judge.
You bet. Ms. Charles, anything else?
No.
That was a long plea. We'll go off the record. I'm going to let the folks on Zoom go about their business. You all need to stay and work with Ms. Toussaint to get that last form filled out. Okay. Thank you, Ms. Jackson, for your time. Ms. Rivers, for taking all this down. Ms. Pastor, I wish you and your family the best as you move forward. This doesn't erase anything, but hopefully it at least closes a chapter or starts to close a chapter for you and your daughters.
Thank you.
You're right.